Hey, thanks for making it to Veterans Info Tap. I'm glad you made it. So the Supreme Court ruling, I'm actually going to put that link in the description and in the comments is what I'm going to try to do for you here. That Supreme Court ruling on the veterans who were seeking some additional assistance, I guess, with the benefit of the doubt rule. Now, this ruling was impacting the U.S. Court on Veterans Appeals. Now, I want to jump into this and just kind of shine in what's really happening here, right? By the courts not ruling in favor of veterans, what is actually going to be impacted? And again, I'm putting the actual ruling directly from the Supreme Court in the comments for you. Now, before we get started, I want to throw out a special thank you to Tommy You're So 1811. Tommy You're So 1811. Thanks so much for that super comment, super chat. I appreciate it so very much. Thank you for the support. All right, so there's also another article, and I'll jump into that in a minute. I'll just do the headline here, and then I'm going to kind of give you some off the top of the head stuff, and then we'll dive into the article to see if we could pick out anything else. So, Supreme Court rules against veterans receiving benefit of the doubt for disability claims that are a close call. All right, so the headline sounds horrific because it sounds like it's just eliminating the benefit of the doubt aspect. That is not what's really happening. So I want to kind of explain this, give you kind of the wave top, and then give you my opinion, then we'll jump into this article. All right, so when you file a claim for benefits, you file your claim, right? You get all your evidence together. It's evidence, right? Nobody's helping you on the other side. You're providing evidence. It's being reviewed. It's either ruled in your favor or against you. Then you can basically challenge that decision through a higher level review or a supplemental claim where you're adding in some additional information to your claim to hopefully then rule in your favor. If it is then, again, unfavorably decided and you still disagree, you could push it to the Board of Veterans Appeals. Then it's overseen by a judge. The judge makes the call and moves forward. If the judge at the Board of Veterans Appeals rules against you, right? So they deny your claim again. There's three choices at the board level, right? Remand, approve, deny. Okay, let's say they deny you. So now you're denied again. What can you do? Your next actual recourse is actually the U.S. Court of Appeals for Veterans Claims. Now, you can do that. You can push it there. Again, it's seen by another judge that's then reviewing the decision of the Board of Veterans Appeals. I get it. There's a lot going on. But these are, I guess, safety net aspects in the appeal process to get your claim fully adjudicated, ideally, appropriately. Now, in this specific court case that went to the Supreme Court, first of all, this isn't, a couple veterans I think that they could have picked maybe some better cases. They could have found some additional cases that had a little more, I guess, substance. But in any case, there's two cases that went to the Supreme Court. Now, the fact that the Supreme Court took this on was a big deal. Okay, so there's bunches of cases that get presented to the Supreme Court. They pick and choose which ones they're going to run with. So the fact that they actually chose this to run with was a big deal. Their decision, thus, is a big deal. Now, the decision was, I believe, a 7-2, 7 basically saying no, was really around the idea that at the U.S. Court of the U.S. Court of Appeals for Veterans Claims, at that level, they were asking, the veterans were asking that there should be additional oversight on the benefit of the doubt ruled and to really rule whether that was implemented or not. The Supreme Court ruled against that, basically saying that the U.S. Court of Appeals for Veterans Claims should not have to relook at the entire case from scratch. I personally disagree. I think that there needs to be a safety net. The VA obviously does not get things right. So if they don't get all of these things right, what's to say that they're getting the benefit of the doubt rule correct, right? So with that, what does this impact? What does it affect? It affects the U.S. Court of Appeals on Veterans Claims and any sort of claims that get appealed to that level. That's what it affects. And what does it affect in that aspect? In the U.S. Court of Appeals for Veterans Claims, it affects really that they're not going to change anything. They're going to continue to do what they're doing. Now, there are groups out there that said, well, this is just going to allow the U.S. Court of Appeals for Veterans Claims to just keep rubber stamping, looks good, looks good, looks good, and move on. And I kind of agree with that. I think that there should have been some additional pressure or I think that there should be another set of eyes to make sure that all the aspects of the claim have been fully looked at and reviewed appropriately. So with that being said, how can you circumvent this, right? How can you circumvent getting all the way to the U.S. Court of Appeals for Veterans Claims, having solid evidence when you actually apply, right? So oftentimes you'll hear things like, at least as likely as not, in this world of VA claim stuff. And that's great. At least as likely as not is really the benefit of the doubt rule. If it is, teetering and it's equal on both sides, evidence is in equipoise, the VA is supposed to give you, the veteran, the benefit of the doubt. So you're going to hear, at least as likely as not, thrown around. I'm a fan of more than likely. Just without a shadow of a doubt, let's just try to do that everywhere we can. Instead of meeting the minimum threshold, let's go a little bit further. That helps. Getting solid Nexus letters and solid DBQs, that type of stuff, super good. You can get that through your medical provider. Unless it's a VA provider, probably not, most likely. If it's a private doctor out there, they can definitely do it for you. But it's really up to you, right? You're going to have to train and educate your medical provider so they understand what you're looking for, right? In a Nexus letter, in the DBQ, rationale, the legalese that the VA is looking for cross-referencing the schedule of ratings, all of that type of stuff. Now, if you can get your doctor up to speed and they'll write that for you, awesome, do it. If they can't, won't, don't, whatever, you can utilize AME, American Medical Experts. Their link is also in the description and in the comments, so check that out. They will give you a free consultation so you can decide if it's right for you. Look, it's not right for everybody. That's fine. If it makes sense, it makes sense. If it doesn't make sense, it doesn't make sense. But information is free, so utilize the free consultation. All right. So now that we kind of have an idea of what has happened, let's jump into this article real quick. So it says here, Supreme Court rules against veterans receiving benefit of the doubt for disability claims that are a close call. This specific article was on Stars and Stripes. I'm sharing it with you here today. The Supreme Court has rejected an argument by two veterans that the Department of Veterans Affairs had a duty to grant their claims for PTSD when the evidence showed the decision to be a close call. In a 7-2 ruling, the court said the VA does not need to apply the benefit of the doubt rule, a standard of proof that favors the veteran when there is a balance of positive and negative evidence. The decision supported the findings of the VA claim specialist who denied the veteran's disability claims. One veteran sought a claim for PTSD, a mental health condition diagnosed in individuals who have experienced trauma. The other petitioned for a higher disability rating for his military service-connected PTSD, so an increase. The High Court supported the federal government's argument that the appropriate standard of review depends on whether the challenge is factual or legal in nature. And that's the difference, right? These things are really on the legal aspect of things. So moving on here, again, I put the link to the actual U.S. court, the U.S. Supreme Court's decision that just came out in the description and in the, I'll put it in the comments too. All right, so Justice Brown Jackson, voting in the minority with Justice Gorsuch, wrote in the dissent that the U.S. Court of Appeals for Veterans Claims, also known as the Veteran Court, will continue rubber stamping denials of VA claims instead of delving into the evidence. I full-heartedly agree. I think that the Supreme Court got this wrong. For these specific cases, look, I don't know about these specific cases, but I think that the court should absolutely look into evidence as it relates to the benefit of the doubt rule and the level of evidence supporting and not supporting a given claim. The Supreme Court reviewed a pair of similar cases, Bufkin versus Collins. So this used to be Bufkin versus McDonough, but since McDonough's out, or however you say it, but McDonough, whatever it is, the old VA secretary's out. Now it's the new VA secretary, so that's the difference in the last name. So now it's Bufkin versus Collins and Thornton versus Collins. Collins' name as the defendant in the cases is the VA secretary. Joshua Bufkin served in the Air Force from 2005 to 2006, and Norman Thornton is a Gulf War Army veteran who served from 88 to 91. Bufkin obtained a non-prejudicial hardship discharge from the military after he said his wife threatened suicide unless he left the service. According to court documents, he filed a claim for PTSD related to his military service and marital strife that it caused at home. Bufkin was denied disability compensation for PTSD after his doctors disagreed on the diagnosis, according to the court records. Thornton had sought a higher disability rating for his established medical diagnosis of PTSD, but was denied. He had been rated with a 50% disability, but sought a higher rating, arguing his mental health condition affected his ability to hold a job. Petitioners are veterans who applied for service-connected post-traumatic stress disorder disability benefits and were dissatisfied with the VA's resolution of their claims. The Supreme Court wrote in its syllabus of the case. Attorneys for the veterans argued the Veterans Court had a duty to reevaluate the evidence in the veterans' cases based on the benefit of the doubt rule. But the Supreme Court said the Veterans Court can overturn a decision only when there is clear error. The Veterans Court has the authority to decide relevant questions of law and set aside VA findings that are arbitrary and abuse of discretion or otherwise not in accordance with law, according to the majority opinion of the Supreme Court. The court stated in its own opinion that Congress provides veterans with a wide range of benefits, including compensation for disabilities caused or aggravated by active duty military service. The VA administers the laws that provide for those benefits. Veterans can appeal denials of VA claims to the Board of Veterans' Appeals, which reviews the contested claims. If the appeals board rules against the veteran, the dispute claim can be challenged before the U.S. Court of Appeals for Veterans Claims, or Veterans Court. Attorneys for the veterans argued the benefit of the doubt rule has been used to decide disability payments for veterans for more than a century, but the federal government countered the role of Veterans Court is to review disputed cases for errors. Bufkin and Thornton filed challenges in the Veterans Court after their cases were rejected by the Veterans Appeal Board. The Veterans Court has exclusive jurisdiction to review final decisions of the board according to court documents. In both cases, the Veterans Court agreed with the denials made by the VA claims specialist. When the veterans later challenged the rulings in the U.S. Court of Appeals for the Federal Circuit, the court sided with the government and said the decisions were properly reviewed and handled. There's a quotation here at the end. "We hold that the VA's determination that the evidence is in approximate balance is a predominantly factual determination reviewed only for clear error," Justice Clarence Thomas wrote in the majority opinion. With that concludes it. Thanks for watching. I appreciate you so very much. Have a great one. And remember, if we don't take care of each other, something went wrong.